House Judiciary today, Tuesday, March 5th. Before we start, I do just want to mention, as I did yesterday, that we have a new committee assistant, Fran, and she will email the testimony to all of your emails as Kathy did before. And then Fran also will put it on the S drive. So you'll have that in addition to your emails. And as we did before, if you would like paper copies, well, we'll always have an agenda paper, but if you would like a specifically paper copy, Fran will just make sure that as she emails you who want a paper copy, that it's convenient and easy for your office assistants to print your pages. So might just double check with her that she's sending that to them so that, yeah, you do anyway. Okay. All right. So that's how we'll be operating from here on out. And today we have 2 hearings. We're not going to work any bills today. I'll tell you at the end of today kind of what the plan is for tomorrow. But for today, we're going to have a hearing on Senate Bill 190. I'll go ahead and open that hearing and ask the reviser to give us an overview of Senate Bill 190.
Thank you, Madam Chair. Senate Bill 190 requires a waiver of extradition proceedings as a condition of release prior to trial for any person that's charged with a felony. Section 1 amends KSA 222802, the statute in the Kansas Code of Criminal Procedure that relates to release prior to trial. The bill adds a new subsection to the statute to create an additional condition of release. For any person who's charged with a felony, the magistrate shall order such person to execute a waiver of extradition. The waiver shall state that such person consents to extradition to Kansas and waives all procedures related to extradition if the person is arrested in another state while on bond, and acknowledge that the person shall not be released prior to trial in any other state pending extradition to Kansas. And I can take any questions.
Okay, committee, do you have any questions for Natalie? Representative Osmond and then Representative Carmichael.
I have a feeling I might be asking the same question. I'm going to do the Carmichael special.
I knew it. I didn't look that up today. As I was walking up to give this brief, I was like, oh my gosh, I forgot to look up what that was. There was a House bill that was substantially similar, if not identical to this bill last year, and I can find that information. If the proponents don't bring it up in their testimony, I'll find it for you. Mm-hmm.
That answered your question? Okay. Any other questions for Natalie, committee? Okay, thank you so much. Our first proponent is Sheriff Jeff Easter, and I believe that will be on WebEx. Sheriff, welcome to committee. Thank you for being with us.
Thank you, Chairwoman Humphreys and committee members. I'm Jeff Easter, representing the Kansas Sheriff's Association. This bill has been introduced by the Johnson County Sheriff's Office, which is a border county to Missouri, and the Kansas Sheriff's Association stands behind them on this bill. There is a lot of folks that are out on bond that skip bond, have felony warrants, and are right across the border in Kansas City. The current extradition process causes a lot of bills to have to be paid to that sheriff who's holding them for at least a month until the extradition process can take place. So we are in support of this bill, and I'll take questions at any time. Thank you.
Okay, thank you. I think we'll go ahead and do questions now since we don't have a long list of proponents. Committee, what questions do you have for Sheriff Easter? Representative Carmichael.
Thank you, Madam Chair. It's always good to see you, Sheriff.
You as well, sir.
Indeed. Always good to see you in the legislative context rather than with red lights behind me. Yes, just make it clear. In the testimony of the Kansas State Board of Indigent Defense Services, they point out that at the beginning of their written testimony, at least, that they believe that this bill, to paraphrase, unconstitutionally mandates that courts impose the condition on presumptively innocent persons without any individualized findings of necessity or the ability to impose the pretrial release condition in the least restrictive manner necessary. I only see two proponents today, both of whom are from law enforcement. I know that you're not a lawyer by trade, but would you care to respond to what seems to me to be a persuasive argument made by the defense lawyers?
But I can only take it from a standpoint of how we deal with this issue in Sedgwick County. And so if we have someone that skips bond, has a warrant put out for them, and they're in Texas, currently right now, we have to go through the extradition through the governor's office. Folks can waive extradition. Most of the time they don't. And then extradition is granted. I don't know a single time when extradition wasn't granted. And then we have to fly down to Texas or Arizona, wherever, to pick up this prisoner, bring him here, and then that process that you talked about starts. I'm not aware if that process starts while they're being held in another state, while the extradition order is being written by the governor.
And I appreciate your answer. I'll probably just have to take the opinions of the lawyers as conclusive, and I won't try to put you on the spot. But you will be sad to know that back in the 1860s to 1880s, there were, in fact, extraditions denied by other states to Kansas in connection with, of all things, county courthouse wars. But I think that was before both of our time, Sheriff. Thank you.
long, long ago.
Committee, do we have other questions for the sheriff? Okay, I think we're great. Thank you so much for joining us. We appreciate it.
Thank you.
Committee, next we have Greg Smith. If you will introduce yourself when you come up, that would be great. Welcome to committee.
Thank you, Madam Chair. Greg Smith, I'm with the Johnson County Sheriff's Office. I'm the legislative liaison for the Sheriff's Office. This bill has been around for a while. SB 457 was around in 2022, passed the Senate, came over here to the House, came to this committee, had a hearing, and it stopped. So we're hoping for a better outcome this time around. This is a situation with us as a border county. People don't really care about state lines when they commit crime. We have a lot of people that live in the Kansas City, Missouri area or the greater Kansas City area, come over to Kansas, commit a crime, and then go back home, which makes it very difficult for us to get them back in the state due to the extradition laws. As Sheriff Easter said, I don't know. I can't think of a time with our agency where we've had an extradition denied. I know historically it has happened in the past. But what this does is the defendant in this case, if it's a felony, would just sign the waiver of extradition saying, hey, if I'm in another state and I don't show up for court, I'm not going to fight the extradition. I'm just going to come back, which would save the agency a ton of money, the state a ton of money, and a lot of man hours that could be saved as well. And I kind of outline that process in my testimony on page 2, talk about the different things that go on there. Usually you're looking at a maximum of 30 days that a state is going to hold someone that's out on some type of fugitive thing. They could then put them on bond in their own state. That can be done. The assumption is the person will go back to whatever state they have their original charge in, but that doesn't happen very often. What we have found in our jurisdiction is 78% of our extraditions in Johnson County come from the state of Missouri. We had 246 fugitive cases where folks had gone out of state, and 193 of those cases were Missouri. The greater portion of those were the Kansas City, Missouri area. You're talking about somebody that's 8 to 12 miles away, and we can't get them back into the state without going through a very laborious and costly process. You will hear testimony, written testimony. I don't know if they're here in person today. Magistrates to make individualized decisions concerning conditions of release. We don't think that this is actually a true narrative. It's more of a false narrative. Magistrates are bound by statute now on what they can and cannot do as far as conditions of bond. This is just something that would be in law that they would have to follow. You'll also hear that the bill raises, quote, constitutional and ethical questions, unquote. We don't believe this is the case. Constitutional rights are routinely curtailed when someone is on bond. They're frequently not allowed the right of association because they're prohibited from going to certain places or seeing certain people. In fact, if you're on a person felony or person misdemeanor in Kansas, you're usually there's a 72-hour time period where you cannot associate with the victim. That's just part of your bond condition. Second Amendment rights are often nullified when you're on bond. You can't possess a firearm, and people are often told that they can't ingest or partake of certain substances while they're out on bond. So we don't feel that this is a big constitutional issue. We modeled this after Colorado law. Colorado's had this law since 2013. We did research. We can't find any place where it's been challenged in Colorado. Not saying it hasn't been, it's just saying we didn't find that information. And so that was the model that we chose when we had this legislation drafted. It would certainly save the state and agencies money and time if this were enacted. And again, I think it's important for the committee to remember these are people that skipped bond. They skipped out and went to another state. These are not people that haven't done something. They have a warrant for their arrest because they failed to appear in court. So we would ask the committee to recommend the bill favorable for passage, and I'm happy to stand for questions.
Okay, thank you. Committee, do you have any questions? Representative Neely.
Thank you, Mr. Smith. I'm just curious and everything, if you could give us just a ballpark and everything of what would it cost and everything for, you said 193 or 200 and everything per. So each one of those and everything, I mean, granted, I know some of them would be different than others, but what would be just an average and everything? So you take all those times 200.
I don't have that cost. I could probably dig around and try to find that for you. What I can tell you is that the amount of people that are involved in trying to get somebody back in the state of Kansas, you're looking at our local county district attorney, the Kansas Attorney General's office, the governor's office, the governor of the state that they fled to, the attorney general of that state, the local prosecutor where they were charged in that state for whatever crime they were charged with there, and all that process of, as the sheriff talked, that we got to fly down to get them where, if they're, not next door, if they're in Kansas City, Missouri, it's just the cost of whatever it is to gas to go get them and that kind of thing. But so costs can vary quite a bit depending on where the defendant is.
Other questions? Representative Carmichael.
Thank you, Madam Chair. Deputy Smith, I think you have made reference to the testimony from the Board of Engines and Defense Services. I take it you've had a chance to review their testimony?
Have.
Would you be kind enough to share with us your legal analysis as to why the doctrine announced in United States versus Salerno, and as explained in some detail in Bidd's testimony, is inapplicable to this legislation, because on its face, I find their written testimony very persuasive?
Well, I understand that you do, and I am not an attorney, so I'm not going to attempt to defend that those statements or make statements against those statements. All I can say is that our feeling, as I outlined in my testimony, is that it is not unconstitutional. It's been functioning now for 10 years in Colorado, and we can't find a legal challenge to it.
Well, I'll tell you what, I request that our that our legislative research people do a search on that Colorado statute that is included in Bidd's testimony, in the deputy sheriff's testimony, so that we can see for ourselves. And I appreciate your feelings, Deputy. Thank you.
Thank you. Jordan, if you would do that and then let the whole committee, that would be really helpful. Thank you. Representative Lewis. Mm-hmm.
Thank you for being here. Have you had an occasion to speak to some of your colleagues in Colorado to see how this is working for them?
I have not. spoken with them. This bill, like I said, it's been around for a few years. And I've been working mostly with our fugitive apprehension unit. They have made contacts with some of their counterparts in other states. I don't know exactly which states that they have spoken with. All I can say is that we haven't found an issue yet. I'm not saying they're not out there. I'm just saying we haven't found them.
So, for instance, Missouri, do you know if they have a similar law that applies when Missourians come over to Kansas?
Missouri, I don't think does have a similar law. Colorado does. North Carolina does. There's one other. I can't pull it off the top of my head right now. I apologize.
Thank you.
Mm-hmm. Committee, any other questions? I had a quick question on, and this could have maybe been a better question for Sheriff Easter with the whole Sheriff's Association, but is the same issue in Oklahoma, like our southern border that maybe you're having with Missouri? Do you have any numbers? Like, what are we talking here as far as how big a problem it is?
Yeah, I can talk to our numbers to Missouri, since that's
yeah.
really our border. Down south, I don't really know. I don't know if Mr. Klump has any information on that, because he does represent KSA at times. I know I threw you on the spot.
Sheriff Easter's still on the line.
He is still online. Sheriff Easter, if you're still there, do you have any numbers, or do you know if Oklahoma, if we're facing some of the same issues on the Oklahoma border?
So don't have any numbers. The sheriffs that are border counties along Oklahoma, Colorado, Nebraska, and Missouri, not just Johnson County, have all voiced that it's an issue. And it's an issue just because they're right across the border in some of those towns. And you have to go through the entire extradition process, which those border counties on the other side, say it's Missouri, Colorado, Nebraska, they charge you a fee for every day that prisoner is in their custody. So they're getting charged fees to house them when they're just right across the border. And so that's been usually the what I've heard from the border sheriffs. That's why the bill was introduced back in 22, because there was a lot of talk amongst the sheriffs back then.
Okay, yeah, thank you for that information. I appreciate that. Are there any other questions for Mr. Smith? Okay, thank you so much. Appreciate it. Okay, committee, that is all the proponents. I'm sorry, another question. Yes, Representative Heiberger, how happy I am to call on you.
Well, thank you. I'm happy to be called on. I'm sorry I didn't do this earlier, but you have a revisor question, if that's all right?
Yep, Natalie, go ahead, and Natalie can answer.
I noticed the bill heading says it's been amended by the Senate Committee of the Whole. I could not find the change that was made.
Madam Chair, Representative Heiberger, this bill was introduced in 2023, so it's a carryover bill. So the floor amendment was just striking the 2022 sub-references. You'll see those in the title in line 8, but that was the floor.
I couldn't tell the bold-faced italic strikeouts.
Yes.
Yeah. Okay, thank you. Good question. Any other questions, committee? Okay, we will now hear from the opponents. Catherine Stevenson from the Kansas State Board of Indigent. That's written only. I'm so sorry. Okay, so it is rather lengthy. It's been referenced several times. If you all would please take a look at that, and so you know what that's all about. Okay, are there any other neutral proponent, any other conferees on House Bill or Senate Bill 190? Okay, then we'll close the hearing on Senate Bill 190, and we'll open the hearing on House Bill 2780, and again, call on our revisor to give us a synopsis.
Thank you, Madam Chair. House Bill 2780 requires persons who file lawsuits for wrongful conviction compensation to prove additional information. It also changes the compensation rates to daily instead of yearly rates, and it limits housing assistance offered to those persons. The bill amends KSA 60-5004. That's the statute that provides the civil right of action for wrongful conviction. New subsection B2 is added to provide that a person shall not bring an action pursuant to this section if their conviction was reversed or vacated based on ineffective assistance of counsel. Current law in subsection C requires the claimant to establish that the claimant did not commit the crime or crimes for which the claimant was convicted and was not an accessory or accomplice to the acts that were the basis of the conviction and resulted in a reversal or vacation of the judgment of conviction, dismissal of the charges, or finding of not guilty on retrial. This bill divides that into two separate clauses, requiring the claimant to establish that the claimant did not commit the crime or crimes for which the claimant was convicted, causing the conviction to be reversed or vacated, or the charges to be dismissed, and the claimant was not an accessory or accomplice to the acts that were the basis of the conviction. A new subparagraph D is added to require the claimant to establish the claimant's own conduct, including any action taken by the claimant before, during, or after the commission of the acts that served as the basis for the claimant's conviction, did not contribute to, cause, or bring about the conviction. Current law in subsection E provides that damages shall be $65,000 for each year of imprisonment, not less than $25,000 for each additional year served on parole or post-release supervision, and an amount not to exceed a total of $25,000 for attorney fees and costs, unless a greater reasonable total is authorized by the court. This bill would change those amounts to $180 for each day of imprisonment, $70 for each additional day served on parole or post-release supervision, and an amount not to exceed a total of $100,000 for attorney fees and costs. The bill also adds a provision providing for damages of $110 for each day spent under a house arrest program, and another provision limiting compensation for days of imprisonment to days spent in the custody of the Secretary of Corrections and any time served in jail awaiting post-trial transfer to the Department of Corrections. Current law also allows for relief in the form of housing assistance, and this bill limits the time period for which you can receive that assistance to 5 years. Subsection K is amended to provide a definition of housing assistance, which is monthly payments to a rental facility or financial institution in an amount not to exceed $2,000, which will be adjusted every 5 years based on the Consumer Price Index for all urban consumers in the Midwest region. And then finally, current law provides for relief in the form of counseling, and a definition for that term is added to provide that counseling means services for mental health, career placement, substance abuse, disability rehabilitation, and family reunification. And I can take any questions.
Okay, thank you so much. Committee questions for Natalie. Okay, thank you for that explanation. Committee for proponents, we have Robert Hutchison, Deputy Attorney General. Welcome to committee, and thank you for your testimony.
Thank you, Madam Chair. As you said, I'm Deputy Attorney General Robert Hutchison, and I'm here to provide testimony from the Office of the Attorney General. For the past 5.5 years, the Attorney General's office has been litigating claims raised under the Wrongful Conviction Act, and the changes we've proposed in the bill come out of that experience, where areas where courts have reached deferring interpretations, or there's been some confusion between claimants and the state. The first of the proposed changes deals with the language that would preclude an individual from submitting a claim on the basis that their conviction was overturned or vacated due to ineffective assistance of counsel. And I will note, as indicated in the testimony, we are supportive of an amendment that may come later that would provide, I think, better language on that, so that they're not submitting a claim solely on that basis. We don't actually see that as a change in the substantive law of the acts, as the law itself indicates that someone needs to demonstrate that they didn't actually commit the crimes of conviction, and in fact defines a claimant as someone who did not commit the crime that they were convicted of. So someone shouldn't have been entitled to compensation solely on the basis of ineffective assistance in the first place. But district courts have reached deferring opinions, and we would like to have that clarified to make sure the original intent of the legislature is made clear. Additional changes, the revisor noted splitting Section C into two areas where they, and the reason for that is that courts have deferred on whether that is two separate things a person has to prove or whether they can just prove one or the other. And it appears to us that both are necessary elements for a claim. We would like to have that clarified in the statute as well. Other changes are the result of administrative challenges, such as the bill doesn't indicate that a partial year served would be prorated out. It has been our practice to do that in agreeing to awards, but we wanted to make that explicitly clear by setting a per day compensation rate. And that actually accrues to a larger per year benefit for eligible claimants. Further, the housing benefit wasn't defined before. It was listed as what the statute calls non-monetary compensation. The reason it's non-monetary is because it's not paid directly to the claimants, but rather to service providers or a business. We wanted to define that so it was a clear benefit that the claimant could actually receive, as well as put a time limit on it for 5 years. Finally, one of the other significant changes is the attorney fees provision. As written presently, it's listed as a soft cap of $25,000, unless the court makes a finding that more is warranted. We've only had, I think, one case go over that, and it was still well short of the $100,000 limit we're proposing, but it gets rid of the need for the court to hear additional considerations to make a finding to award attorney's fees over that amount as appropriate. And just to kind of close with a highlight of the action on this act since it was passed, in 5.5 years, there have been 25 wrongful conviction claims submitted. 8 have been paid out for a total compensation of $4.3 million, and 5 have gone to trial. Several of those are presently on appeal, and one trial just happened at the end of January, and we're waiting a decision on that. In just 5.5 years, the Kansas Supreme Court has already had the occasion to issue 4 different opinions. On 3 of them, they affirmed dismissals of the claims as matters of the law. And on the 4th one, they overturned the decision of the court and sent it back to trial for further consideration. I believe my testimony covers explanation of the rest of the changes, and I'm happy to stand for questions at the appropriate time. Thank you.
Thank you very much, Madam Chair. You know, we're actually just joking earlier that, on judiciary, fiscal notes don't really matter all that much, but I'm looking at the fiscal note because I think in this case it does matter. And I wanted to try to find out how much this bill would cost or how much this bill would save. And I don't exactly have that information here. So my question to you would be, how large of an issue is this? And is this solely, or is this primarily a monetary issue that you're trying to rectify here?
I wouldn't call it a monetary issue, Representative, but I appreciate the question. The problem is, I believe of the 25 cases we've had, 6 have been claims based solely on ineffective assistance of counsel and not on the actual innocence of the party. That's a lot of time that we're handling those cases, litigating those cases, handling them on appeal. For cases that, as far as we've read the statute and have for 5.5 years, shouldn't have made it past a motion to dismiss in court in the first place. As we find actual innocence of the party is a prerequisite stated clearly in statute. We wanted to make that clear so that courts couldn't find a reason to have deferring opinions, and those claims that shouldn't be occupying so much of our time and resources can't continue to do that.
Thank you, Madam Chair. Mr. Hutchinson, it's good to see you someplace else. I have a question about section C1D on page 2. You have there's the new section about the claimant's own conduct. This is a new element that the claimant would be required to prove. It seems to me like this requires the claimant to prove a negative, which can be really impossible. And so, I mean, could you tell me how this would work in practice? And then secondly, wouldn't it make more sense to add something saying that the claim could be disallowed if the state demonstrates that the claimant's conduct, contributed to the conviction?
Madam Chair, Representative Hyber, it is good to see you again. It has been a little while. I'm glad to see you back here at the legislature. In this case, the change breaks apart 2 different sections, and the own conduct provision is significant for us because it's part, as far as what we can see, of the claimant proving that they didn't commit the crimes of conviction or that their own conduct didn't contribute to the ultimate conviction. An example I can give you is an individual who was in a fight with a neighbor, went into his apartment and got an AR-15, came back out. The neighbor kept charging at him. He fired a warning shot. neighbor kept coming, and he was going to try and shoot at the ground, but he ended up shooting him in the stomach and killing him. And he was originally convicted of, I believe, second-degree murder. Ultimately, after serving significant time, that conviction was overturned. And on retrial, he was convicted of involuntary manslaughter. In that case, his own conduct in shooting the person in the stomach still caused the ultimate conviction. There wasn't any question that he committed the acts that led to that. It was just legally, there wasn't found to be sufficient evidence to underscore the original conviction. So in that case, he would be ineligible as far as we're concerned because of the own conduct provision. And the rest of the statute requires the claimant to meet certain evidentiary burdens. To just flip that around in the state would seem a little inconsistent with the rest of the statute.
I get that, and I get the reason for it, but it seems like the way it's stated here, I mean, you're asking the claimant as an element to prove that none of his actions contributed to the conviction, and you have to start at third grade saying that I didn't do anything bad. I mean, you see what I'm saying about the difficulty of proof on the way that the thing is stated now?
Madam Chair, Representative, I think the scope would be narrower just in terms of what he has to prove for the claim. For example, he didn't suborn perjury at trial that helped contribute to the conviction. He didn't intimidate a witness or in some other way, or like the gun conduct I related earlier, contribute to it. I can't imagine a court trying to ask that you need to prove that a bad conduct report from third grade ultimately contributed to it. I think that the scope of it is contained within the rest of the statute itself, but I appreciate the inquiry.
Representative Carmichael and then Sharper.
Thank you, Madam Chair, and I will echo my colleague Representative Heiberger's words that I don't know if it's nice to see you in a different context, but you've always been very courteous to me when you served as chair, and I appreciate it. Refresh my memory from your testimony. How many total payouts have there been as a result of the statute that we enacted, 6 years ago?
Madam Chair, Representative Carmichael, this is a little more complicated than the SRB business we were handling last year, but again, it is good to see.
It is indeed.
We've had 8 total payouts over the course of 5.5 years, totaling $4.3 million.
And of the 8 payouts, how many of those were based on ineffective assistance of counsel?
Madam Chair, Representative, none. They were based on actual innocence claims.
But isn't actual innocence a requirement now under the law? I don't think there's an exception, is there, for ineffective assistance of counsel in the absence of actual innocence?
Madam Chair, Representative, I can't speak to the specific appellate standard for actual innocence or for ineffective assistance of counsel. But we're simply looking to make sure that the statute adheres to the requirement that they didn't commit the act, and the court would need to make a finding dismissing their or overturning their conviction on that basis.
With respect, I think that this committee, and if I recall correctly, it was under Chairman Finch's tenure with Representative Ralph, who's sitting in the back as our vice chair, that we were very careful to make sure that it only applied to cases where there was a showing of actual innocence, which would lead to the conclusion that ineffective assistance of counsel in the error, so to speak, would not be sufficient. Is there some case or some language that you rely upon to suggest that Chairman Finch, Vice Chair Ralph's, and my efforts were ineffective or inappropriate? Because you're kind of challenging what we did, and I'd appreciate some authority.
Madam Chair, Representative, we're not making any attempt to challenge what you did. What we are dealing with is claims made by claimants that don't allege that they were actually innocent in the crime and rely solely on the fact that their convictions were overturned for ineffective assistance of counsel at some point in time for their claim. If the determination that they had ineffective assistance of counsel produced an overturning of their conviction, and there's an actual innocence component to it, then they would be able to satisfy the statutory requirements to demonstrate that they did not commit the acts of conviction.
Madam Chair, with your leave, I'd like to turn to a somewhat related area quickly.
Okay, you may.
Thank you. The testimony of Ms. Rojo Bushnell of the Innocence Project. Have you had a chance to review her testimony prior to today, or prior to your testimony here?
Madam Chair, Representative Carmel, I have not yet read it. I read the first couple of paragraphs during the prior hearing, but I have not read all of it.
Let me try to help you as best I can with that and drop down to about the 5th paragraph, which is at the bottom of the first page. She discusses there the circumstance where, let me, with the chair's leave, kind of use her words. She says, in most exoneration cases, the defendant raises a number of constitutional claims, most often including ineffective assistance of counsel, due process violations, and/or state misconduct claims. And then she poses the problem with what happens under your proposed bill when perhaps the court says there's 3 claims here, but we can see it's clearly ineffective account assistance. We're going to overturn this claim without ever actually reaching due process violations or prosecutorial misconduct. There's a new phrase for that in the law. I don't remember what it is. I want to give you a chance to address the argument that she makes, because it would seem like any instance of ineffective assistance of counsel under the bill you propose would be, in essence, a get out of jail free card for the state, even in instances where there were due process violations, prosecutorial misconduct, or otherwise.
Madam Chair, Representative, I wouldn't say it's a get out of jail free card. I would say that if the only findings are that there was prosecutorial misconduct or something other than actual innocence, then they wouldn't fall within the parameters of the statute, even as currently written. But there is one of the complications of having cases go forward where their basis of their claim is ineffective assistance is effectively having to retry the entire criminal case to demonstrate whether they were guilty or not. If they only raise the claim on the basis of ineffective assistance and they're trying to meet their ultimate burden to prove that they didn't do it, we're deposing witnesses again, retrying evidence, rather than reviewing a court determination that they were innocent and granting compensation under the act.
Chair, there's another area I'd like to explore, but I know it's someone else's turn, and if time permits later, I'd appreciate a second opportunity.
Okay, thank you. I'll keep that in mind. Representative Schreiber.
Madam Chair, I love hearing Representative Carmichael. I'll pass on my question so he can do his.
Okay, committee, are there any other questions? I'm going to go ahead and ask a question specifically about what Representative Carmichael was just speaking of, that when I first read the bill, I had a little bit of a concern too, that if someone had, as you know, if someone had, their claim was about their ineffective assistance of counsel, that, but then what if they also were truly innocent? And so you would be amenable to an amendment that would clarify that it could be both. I mean, if it were both, they could still follow through with their claim.
Madam Chair, thank you for the question. Yes, I absolutely would not want any change here to eliminate someone who was eligible from eligibility going forward. So as I can understand some potential confusion with the language of B2 on the first page as presently written, to suggest that if they had a claim that, if their convictions were overturned on actual innocence and ineffective assistance counsel, that just because they also had the ineffective assistance, that finding could preclude them from compensation. I would not want that situation to arise. So as we've discussed, I believe the reviser had helped some language to fix my more litigator oriented language and make it more legislatively workable so that it doesn't eliminate people who should have been compensated.
Thank you. I appreciate you working with that too. Okay, committee, any other questions? Yeah, Representative Vaughn.
Thank you, Madam Chair. I did have one question about your clarification of the housing assistance provision. I'm just curious, how did you come up with the 5-year number? Is that average for reentry services that are provided for housing assistance? I just want to make sure that's long enough for anyone who would be eligible for these claims.
Madam Chair, Representative, I don't actually know where specifically the 5 year came from. I think it was deemed to be a reasonable amount of time once compensation is granted to help provide assistance while the individuals are getting back on their feet, finding employment, going to school, reuniting with their family, what have you. But that it wasn't a specifically defined benefit before. So it could either be 5 months or perpetually. This just provides definition to what that benefit actually is.
If I may, Madam Chair, is the 5 years consistent with what has been in practice prior to now, or do you know?
Madam Chair, Representative, prior to now, they've been on a case-by-case basis. Most of the claims that we've been dealing with outside of the pure statutory compensation have been state benefits and payments and enrollments on that. So I'm not sure exactly if we've had anyone with long-term leases that we've taken up under the Compensation Act.
Okay, thank you.
Any others? Representative Carmichael.
Thank you for allowing me an additional area of inquiry. Back when we passed this legislation, my recollection is that we had some serious discussions about what we ought to do with attorneys' fees, whether we ought to award them at all, whether we should set a floor, whether we should set a ceiling. And eventually the compromise was no more than $25,000 unless there's a finding by the court of exceptional circumstances. And I think I heard you say that there has not been any of the cases thus far in which a court has approved attorney's fees anywhere near even the $100,000 limit that you propose. Did I understand that correctly?
Madam Chair, Representative, I believe the highest award we've seen is $68,000 with a finding of exceptional circumstances in that case.
My recollection is that was part of a big compromise on attorney's fees because we wanted people to be able to have representation, realizing that other than bids, which typically is not involved in these civil actions, that lawyers usually don't work for free. But at the same time, we wanted to make provisions so that if there was an unreasonable failure of, frankly, the state to settle claims that ought to be settled, and people are just being taken to trial as a matter of routine, that in fact their lawyers would be appropriately compensated. And those were the rare instances, and that's why we put it in, that there had to be such a showing. It seems to me that there hasn't been any abuse of the process, that you haven't had any case where the fees came anywhere near $100,000. Why do we need to impose a limit in the absence of a showing of abuse of the current statute?
Madam Chair, Representative, we actually thought this was a plaintiff-friendly change to create a greater incentive of the potential for up to $100,000 in fees to get that representation that we're looking for. If we've been, mistaken on that, then I'm sorry.
Well, I apologize, Madam Chair, but I interpreted your bill to say that even in the face of the court finding special circumstances, i.e. abuse, that the limit is $100,000. So how does limiting the legal fees encourage lawyers to take what could prove to be a very difficult case if some other attorney general, some other day, implemented practices different than your office, as well as Attorney General Schmidt's? How in the world would putting a limit on the possible fee encourage a lawyer to take a case? I didn't do very well in business and law. Help me.
Madam Chair, Representative, the ease is getting rid of the soft low cap of 25,000 and getting rid of the burden to prove that there were extraordinary services that entitle them to go over that. Because short of that, they could have costs of $80,000, and if the court doesn't make a finding, they're eating $55,000. So it was a trade-off in terms of getting rid of a soft cap with extra work for a higher but firmer cap.
So is it really important to the AG's office one way or another if this was designed for the benefit of the plaintiff's bar, if you will? We really don't need to do this. There hasn't been any abuse. Why can't we just leave it the way it is? And someday if there's a problem, then we can look at it.
Madam Chair, Representative, I'll borrow a word that you relied on. Therefore, there hasn't been abuse yet, certainly. But so a high ceiling or a hard cap works against future abuse, just as a soft cap with a finding works against a different potential for abuse. But I would not characterize that as anywhere near the most crucial part of this bill.
No, I appreciate your position. I don't entirely agree, but thank you, Madam Chair.
Committee, do you have any other questions? Okay, thank you, Mr. Hutchison. We appreciate you being with us.
Madam Chair, members of the committee.
Committee, I'll now call up Tricia Bushnell, Executive Director, Midwest Innocence Project. It's written only. Sorry, I'm not calling her up. It is written only. So I hope you will also look at her, at the Innocence Project opponent testimony. It's about 1.5 pages long. Okay, are there any other questions, any other proponents, opponents, or neutral that would like to speak to this bill? Okay, then we will close the hearing on House Bill 2780. And committee, tomorrow I intend to, we'll have a hearing on, it's a Senate Bill 394. We have heard this bill before, the exact language, but we're going to hear the Senate version of the House bill. It was the age verification bill. We'll have some abbreviated testimony, or we'll see what happens tomorrow, but that's what tomorrow will bring. I also do intend to look again at House Bill 2510. So you know that would be coming up. And then also at Wednesday or Thursday, we may take up what we heard today. So be prepared for working those bills. If you have anything that you want, any amendments or anything you might be interested in. Okay. Yes, Representative.
Thank you, Madam Chair. When you say that we may take a look at HB 2510 tomorrow, does that mean that we need to contact the reviser and have amendments ready as in working the bill? Or are we looking at it or discussing it? I don't want to put people to unnecessary work.
It's my intention to go ahead and deal with it, which would be to work it. If you do have amendments, it would be great to go ahead and get those in the works now. Any other questions? Okay, committee, yay, 420. This has to be a record. So thank you, everyone. We're adjourned.